I was thinking about those issues, and I thought, I hope this is interesting for everybody as it is for me. So passports down for the moment, and we'll talk about relocation within the UK. And Emily, I wanted to ask you, what sort of application would one be making either to prevent or permit an internal relocation?
Well, I'm probably teaching people grandmothers how to suck eggs, but they fall under Section 8 of the Children Act 1989. They can be part of application for child arrangements orders stipulating where a child will live. Or we can make freestanding applications. So if we're wanting to prevent a move, we can make an application for a prohibited steps order. Or if the parent is wanting to move, we can consider an application for a specific issue order. When the court is considering whether to allow a child to move internally, the question will always be what is in the child's best interests. The leading case is Re C, which is a 2015 case, and where Lady Justice Black considered the previous line of court authorities and set out firstly that she couldn't find any reason for or satisfactory explanation for the different approaches in internal and external relocation cases. And therefore, and secondly, she set out that the exceptionality principle which had developed, or test, which some judges were citing for preventing internal relocations, was part of the welfare of the child analysis. So, therefore, she decided the decision of Re F, which had been decided a few months earlier, in respect of external relocation, applied equally to internal relocations. And therefore, the question, as I said, is what is in the child's best interest, and the court must consider all of the proposals for the child's arrangements, not just the parent proposing to move. So the court will then be undertaking a holistic welfare assessment of each of the proposals so that a comparative evaluation can be carried out. Caroline, we've done some cases together recently on internal relocations. What difficulties have you encountered in the courts recently?
So I think, it's not unfamiliar to anybody about the courts that are finding it difficult to cope with listing. One of the cases that we've worked on, it was an application that was issued in July, and July 2021, and the first hearing listed in May 2022. That was in East London. And sorry, naming and shaming. I don't think we invited anyone from East London, just in case. And you're looking at cases, and this was also something that came to my mind. Talking about this particular topic, is that you're having situations where one parent might have taken the child to go stay at their parents, and that's somewhere else within the UK, and it's already prejudging the proceedings, because by the time we get round to a listing, you're sitting there waiting for months, and this is just the first listing of many, where you might subsequent to that have fact-finding hearings and things like that. So it's causing real havoc on families and real difficulties. And there were other cases that we also worked on together where there seemed to be this sort of, I don't want to call it a magic formula or anything like that, but there was, one parent, instead of applying for permission to relocate, it was to relocate internally, it was the other parent applying to an injunction for prohibited steps order, and then sort of colouring that application with all sorts of urgencies and safeguarding issues, and that seemed to get it in the court slightly faster than others. That was the one that we did, that was in Bristol, that was issued in January, and then within 2 weeks had a hearing listed. So there are some courts that are coping better than others, but it really is sort of luck of the draw. I suppose it's the difference between inside London and outside of London as well.
Yeah.
So, that speaking of urgent applications, I wanted to ask you, what if the situation is urgent, and what kind of emergency applications could be made in those circumstances?
Well, so as you were just discussing, if we're trying to prevent an internal relocation, you can make an application for a prohibited steps order. It's obviously very important for a new status quo not to develop. And I think the case that we did, which then didn't get listed for nearly a year, the other side made an application, and I think probably perhaps slightly sceptically, but highlighted any safeguarding concern they could think of. They just whacked it in there, and that really got it in front of a judge, and a judge said, right, we're going to need to list this in the next couple of weeks. So I think, sceptically, if you wanting to prevent an internal relocation, whack in a prohibited steps order application, highlight any safeguarding concerns, and it will have to be on short notice to the other side, but do it as soon as you can. If the child's whereabouts is unknown, you can of course use the inherent jurisdiction to get some tipstaff orders, or if you are somewhere else already, we shouldn't forget the utility of Section 33 of the Family Law Act 1986, where a court can make an application for a child's whereabouts in family court can make an application for a child's whereabouts in any of the courts. So we really should think about that. We should also remember that if the child has already been taken to a new location, the case of Rayner is very clear that we shouldn't be thinking of these cases like summary return orders under Hague proceedings. The question is always going to be what is in the child's best interests. But don't forget the two cases H and DT, which is a permission to appeal case which was refused, or Rob George's case of BB and CC, which is that the court can always order a parent who has taken a child to a new location to return back. And in BB and CC, Mr. Justice Moore specifically rejected the submission made not by Professor George that there is no different test when ordering one parent to return from part of the country as compared to dealing with an application either to prevent or moving or to grant permission for a parent to move. It's all about what is in the child's best interest. And I understand that was a few years after the child had been removed that Mr. Justice Moore returned.
Fact-finding process before a very robust recorder.
Yes. And I guess what we've been learning from the cases that we've been dealing with on internal relocation, and specifically the delays that are happening at this stage, is to know your court. So we know East London has these ridiculous listing issues at the moment. Croydon, who knows when you're going to get hearings. So I don't want to say this, but choose your court carefully. So if the child has been taken to a court taken to a part of the world where you think they might have better listings, it might be better to issue the application in that court. We're going to come on in a minute to discuss the case of F and G, where which is an Oxford case, like we can discover, and they managed to get from seemingly from the beginning of the application was probably around mid to 2020 to a final determination by December 2020. And I think that's probably because their listing practices are just better. So be very careful about where you're choosing to issue, because then you can hopefully circumvent some of the difficulties that we're seeing specifically in London courts with listing. So Caroline, I had a question for you. If you do ever manage to get in front of a court, what do you include in your statements in these sorts of applications?
Yes. So when you do want to think about your evidence and the statements that you're going to be preparing for an internal relocation application, either as applicant or respondent, and there'll usually be about 1 to 2 statements that you'll be filing, and it's helpful, I think, particularly, without trying to sound too cynical, in cases where you know that papers are being eyelashed, that you want at the beginning of a statement to include a summary of why your position should be preferred to the other parties, and that's sort of giving highlights of the best relevant parts of your case. You're also setting out the relevant background and the situation, particularly in circumstances where relocation cases, your statements are going to be quite lengthy, your exhibits are probably going to be mammoth size, and you're sifting through quite a lot. So to have that sort of almost like a mini position statement at the top summary before you get into the details. You'll want to be highlighting any particular needs that the children might have, your motivation, what your reasons are for the proposed move, and then you'll be fully setting out your proposals about when is the move, where will the child live. You might exhibit some housing particulars if you don't already have the accommodation secured or proposed, and where the child will go to school, and then you're having some school prospectuses exhibited to that as well. And what kind of extracurricular activities the child will be doing, or what will they no longer be able to do, but you'll be putting in place of that so that you're trying to maintain the status quo as best you can. What are the financial consequences? Does the parent proposing to relocate have a new job opportunity? Is the other parent able to also move to where you're moving to? Would they be able to work if they're having their own flexible working sort of arrangements? And importantly, what arrangements are suggested for the time that the child or children are going to be spending with the left behind parent on your proposed move? The children's wishes and feelings, if any of those are known. And you'll also be referring to the points in the welfare checklist, notably. And then, yes, I think some Google Maps as well in terms of distance and that kind of thing. I was trying to think of other exhibits that might be. And I always like to put in pictures, sort of a page, not a family photo album, but at least a page of photos so you sort of, the judge has an idea of who they're looking at. Particularly if you're in Croydon and you have a telephone hearing where nobody can see anybody, so you have a bundle to be referring to. And yes, you wanted to speak to us about that Oxford case, the F&G case.
I did, only because it was the only case recent case I could find, so I'm going to lay it on thick. F&G is a first instance decision, which actually very rarely you'll come to rely on it, but I think it's helpful in the sense that it really sets out how first instance judges are thinking about these sorts of cases. In that case, the parents had reasonably amicably divorced in 2017, and then lockdown hit in March 2020, and the father agreed for the mother to move to a countryside village. We think it's somewhere in Oxfordshire, and mother went there with the two children and quite liked it and wanted to stay. The children was called A and B, and A was younger than B, and B had a diagnosis of autism. And the dad didn't want the children to stay there once lockdown were lifted. And I think around September must have made an application for the children to be returned back to London. And by the time of the final hearing, which, as I say, happened in December of 2020, he had conceded on the basis of the court reports that A, the younger child, could remain in the countryside village, but he still wanted B to come back and live with him in London. And the court simply took a very straightforward analysis of it, compared the two options, and went through the welfare checklist, as you're expecting her to do. And on the basis of the evidence that she found, the judge ordered B to return to London. So separating the siblings, which is an interesting situation, but deciding that as the older child had always been in school in London, that seems to be quite a magnetic factor. But my reading of the judgment is that the judge just didn't really like the mother's evidence, and that ultimately the mother focused too much on the impact of the move for her as opposed to the children, and that she was less concerned about the relationship between the child and his father, and therefore the judge decided it wasn't a child-focused decision, and that the child should be returned. So she should stay in London by that stage. So I think one of the key takeaways from that case is when discussing the case with your clients and when putting in statements is to always refer back to why this decision is in the children's best interests, as opposed to an adult decision of wanting to move. And I think that's sort of an interesting first instance decision that we can all look at and use in our own practices.
Thank you.
So there we go.
Thank you very much. I also just wanted to give a shout out to Sasha Lee, who has an article on internal relocation actually coming out in the Family Law Journal Legalese. So if you want to have a review of that once it's out.
You didn't tell us that when we were writing the report.
I know, I could have just
listed
listed notes. I didn't think of that. I didn't realise that. Yeah, I could have just given that as handouts. But anyways, you'll have to find it yourself. But thank you so much, Emily, for stepping in. And yes, that's very
Thank you very much.
Okay.